All right, Friday. This is the structural shift the legal teams did not plan for. A federal judge just unsealed an absolute mountain of digital evidence. We are talking about encrypted messaging data, Signal, WhatsApp, Telegram. Specifically, an enforcement log containing structural footprints of encrypted data packets across multiple personal devices. This isn't a vague leak. It is a fully coordinated, multi-device forensic capture that just dropped onto the federal digital docket. According to official filings unsealed just hours ago, we are looking at real data markers. This isn't about public speeches. This isn't about tweets or Truth Social posts designed for public consumption. These are raw, private communications that Donald Trump's inner circle assumed were permanently scrubbed from existence. I've spent the last few hours going through every single line of this newly unsealed judicial order. Here's what the mainstream media headlines are completely flying past. The district judge didn't just order a standard document production. The court explicitly categorized the systemic adoption of these encrypted platforms as a deliberate, calculated attempt to bypass federal record-keeping compliance and evidentiary preservation laws. That is not my personal opinion. That is not political commentary. That is page 9, paragraph 4 of the enforcement order sitting on the federal desk right now. You've seen the alerts popping up on your phones all morning. You've seen the sensationalized clickbait headlines screaming across social media. Now, let's look at exactly what they missed. Let's look at the actual facts. Quick context for anyone trying to trace the structural background of this case. Donald Trump, former president of the United States, is currently navigating an incredibly complex web of federal criminal investigations. The core legal battleground here isn't just about political actions. It's about the physical preservation of data. The core issue? Special counsel prosecutors argued before the court that Trump's legal and administrative teams systematically migrated their day-to-day communications away from standard, monitored government channels and deep into high-grade, encrypted mobile software. The objective, according to prosecutors, to deliberately prevent the creation of an evidentiary trail during active federal investigations. Let's hit the timeline fast version so you see how this trap snapped shut. Months back, federal cyber forensics units noticed massive, unexplainable gaps in communication logs during critical investigative windows. Weeks later, grand jury subpoenas forced mobile network carriers to hand over raw cellular transaction records. What did those records show? Clean installations of the Signal and Telegram applications on precise dates that perfectly matched those communication blackouts. Then came the flashpoint. Judge Patricia Morrison issued a definitive ruling stating that these highly encrypted digital conversations are completely unprotected by executive privilege. No immunity, no constitutional shield. That is the baseline setup. Now, let's look at the raw documents, because what makes this specific breakdown entirely different from every other Trump legal story on your feed is one simple factor. This is completely detached from public narrative. This is about what was written in the dark when they believed the encryption keys were absolute. The Department of Justice isn't guessing that these conversations took place. They don't need to guess. They have the hard metadata logs to prove it. Installation timelines, device MAC addresses, active network user logs, exact message volume counts. Trump's defense team fought this specific disclosure order tooth and nail for months. They lost. The legal walls shifted. Now, those underlying data streams are moving directly into the hands of federal prosecutors. Let's look directly at the underlying evidence. First document filed on the morning docket. I pulled page 23 from the unsealed appendix. Look at the exact phrasing here, quoting directly from the federal filing. The defendant installed the Signal encrypted messaging application on 3 separate handheld devices within 48 hours of receiving formal congressional subpoena notification. Read that line again. That is not a media interpretation. That is a matter of official court record. What does this actually mean in a court of law? It establishes a clear chronological link. It shows that the legal team and the defendant actively initiated automated encryption protocols the moment they learned federal investigators were looking for their communications. But here is the section that completely shifts the gravity of the case. Let's move down to page 47, a completely separate forensic section of the unsealed order. The Digital Forensics Division ran a comprehensive analysis on a single targeted device. The log shows exactly 312 encrypted messages sent and received between 11:47 p.m. on June 28th and 6:23 a.m. on June 29th. Think about that timeline. A single night. A 6-hour window. Over 300 highly encrypted communications flashing across private servers. When you align those data points sequentially, the legal pattern becomes undeniably clear. Subpoena notification arrives at the defense desk. Encryption applications are immediately deployed across secondary devices. Communication volume spikes exponentially through encrypted channels. And then, the public-facing channels go completely silent. Everything is documented, timestamped, and verified by external server pings. Now, let's look at what nobody else is covering on your newsfeed right now. The unsealed recipient list on page 51, marked clearly as Exhibit G. This is where the case transforms from a simple record-keeping dispute into an absolute legal firestorm. The metadata shows that the recipients of these 312 encrypted messages include 14 specific individuals who were simultaneously under separate, active federal grand jury investigations. Let that sink in. This wasn't a former president talking to his personal family members or discussing routine business operations. This was a synchronized, highly concentrated communication loop with individuals who already had direct legal exposure to federal prosecutors. Judge Morrison explicitly highlighted this pattern in her judicial commentary. She noted that the exact synchronization of encrypted software adoption among multiple high-profile subjects suggests a coordinated effort toward legal evasion, rather than a simple personal preference for data privacy. The immediate legal fallout from this is massive. Federal prosecutors now possess the absolute, unappealable legal authority to issue warrants to the underlying application companies, forcing them to hand over every single piece of data recovery that is technically possible within their server infrastructure. Furthermore, Trump's defense team has been handed an explicit 11-day compliance window. They must produce all physical devices for complete forensic imaging. Any message, any scrap of data, any partial database file recovered during this window becomes fully admissible evidence across every single pending federal trial. But wait. Within 72 hours of this unsealed order, a massive technical hurdle has emerged for the Department of Justice. Programs like Signal utilize advanced end-to-end encryption protocols. If those 312 messages were configured with automated self-deletion timers, which the unsealed files strongly indicate they were, there might be physically nothing left on the central servers to extract. The prosecution's entire legal framework hinges heavily on metadata, transaction logs, and localized hardware remnants. However, look at page 34. This is where the forensic team found a critical error made by the defense. While Trump's primary personal smartphone had the Signal application configured with a strict 7-day message disappearance protocol, one of the secondary devices, a specific tablet registered directly to his commercial real estate business operations, had that automated deletion feature completely turned off for a window of exactly 19 days before someone realized the mistake and manually enabled it. Do you see what that means? That creates a pristine, untouched 19-day data window where those encrypted messages were never systematically purged from the local hardware storage. The unsealed federal filing actually includes direct screenshots obtained from secure cloud backups, showing partial application database fragments dating from mid-June through the end of the month. Government forensic experts testified under oath that they possess the software capability to reconstruct anywhere from 40% to 60% of the raw text strings from those specific backup remnants. A former digital forensics supervisor at the FBI, a veteran with 27 years of deep tactical data recovery experience, provided formal testimony to the court, stating, "Modern mobile encryption creates significant institutional challenges, but systemic cloud backups and cross-device syncing frequently preserve deep database remnants that ordinary users assume have been permanently wiped from existence." Translation? Even the most secure applications on Earth leave physical digital footprints if the investigators know exactly where to dig. What Judge Morrison focused on in her ultimate decision wasn't whether the text strings could be perfectly recovered with 100% accuracy. Her judicial focus was locked onto intent, whether the systemic use of high-grade encryption specifically to keep records out of federal reach constituted a direct violation of federal preservation statutes. Her formal legal answer was an absolute, unequivocal yes. And remember, that is just the contents of the very first unsealed document. I am currently mapping out the entire 73-page breakdown alongside all attached digital exhibits. Hit that subscribe button right now, because this story has deep structural layers that standard mainstream news broadcasts simply do not have the time or technical expertise to touch. Much more is coming down the pipeline on this. Let's hit pause for a second, because to understand how this case will actually play out in an appellate court, we have to look at the opposite side of the ledger. We have to be completely objective. The defense team has put forward a series of legal arguments that constitutional scholars are calling incredibly substantive. They are arguing that this order represents an unprecedented, massive overreach of the Fourth Amendment. And frankly, when you look at the constitutional case law, some of their arguments hold serious weight. The defense's core position is straightforward. Private American citizens, regardless of whether they previously occupied the Oval Office, retain an absolute, unalienable constitutional right to private, unmonitored communication. Using encrypted communication software is not an admission of guilt. It is not an illegal act. In fact, cybersecurity experts worldwide universally recommend these exact platforms for high-profile individuals who routinely handle highly sensitive, proprietary information that could be targeted by foreign intelligence assets. A distinguished professor of constitutional law at Georgetown University, who has spent over 3 decades teaching Fourth Amendment jurisprudence, summarized the legal dilemma like this. Encryption is fundamentally an exercise of protected speech. Forcing an individual to decrypt their private communication streams is, at its core, an act of compelled speech. That introduces a profound, highly dangerous constitutional crisis. I may not personally align with every single aspect of that defense interpretation, but you cannot dismiss it as nothing. Let's look exactly at the legal gaps they are targeting. No federal statute explicitly bans a former executive or any private citizen from installing encrypted applications on a personal device. The Presidential Records Act contains massive, historic structural loopholes regarding communication managed on purely private hardware during a post-presidency timeframe. Even the American Civil Liberties Union took the extraordinary step of filing an official amicus brief expressing severe institutional alarm over the sweeping nature of Judge Morrison's enforcement order. Quoting directly from the ACLU's formal submission, "If a federal district court can legally compel the systematic decryption of private applications based entirely on metadata patterns, that expansive investigative power will inevitably be weaponized against journalists, political activists, and ordinary citizens." Backdoor judicial access to consumer encryption protocols does not discriminate based on whose privacy it is invading. Short version? The ultimate outcome of this specific legal battle will set a precedent that alters digital privacy laws for every single person watching this video, not just the former president. Look, my role here isn't to tell you which side of this ledger is morally correct. The prosecution's argument is built on a clear timeline of deliberate data evasion, and the physical metadata strongly supports that perspective. The defense's argument is anchored in foundational constitutional privacy protections, and decades of case law support that view as well. Both arguments possess internal legal validity. That is exactly what makes this case one of the most complex legal puzzles in modern American history. Furthermore, the defense team brought forward a highly legitimate security justification that is backed up by official federal records. Throughout his post-presidency, Donald Trump received an extraordinary volume of highly credible, verified death threats. Official directives from the United States Secret Service explicitly recommended that members of his protective detail and immediate staff utilize secure, encrypted communication nodes to prevent real-time location tracking by hostile actors. The defense possesses the exact documentation of those security mandates. So the fundamental legal question before the appellate court shifts. At what precise moment does a standard, reasonable security protocol transform into an act of illegal evidentiary evasion? Trump's appellate lawyers are arguing that federal prosecutors are actively trying to criminalize basic, industry-standard digital safety practices. An official defense filing submitted on Monday lists 11 other high-ranking former federal officials who systematically utilized identical encrypted software during active public service windows. Not a single one of those individuals ever faced a federal subpoena or a threat of contempt for protecting their devices. The defense says this is a textbook case of selective prosecution. Federal prosecutors hit back with a devastating counterargument. None of those 11 other officials were under active grand jury investigation at the exact moment they installed the encryption software. Timing is everything in a federal courtroom. The defense states that privacy is absolute, regardless of the calendar. The prosecution states that the calendar reveals the underlying criminal intent. While Judge Morrison ultimately sided with the Department of Justice, she openly acknowledged the historic ambiguity of the case in her final brief, writing, "This proceeding presents deeply novel legal questions at the absolute intersection of modern encryption protocols, executive privilege, and federal criminal procedure." Even the presiding judge admits this is uncharted territory. This absolute showdown did not just materialize out of nowhere. Let's trace the historical backstory quick. 2 full years back, the very first investigative reports surfaced, indicating profound structural communication gaps during the early phases of the congressional oversight investigations. Investigators discovered that standard cellular call logs provided by carrier networks showed dozens of outbound connections consisting entirely of random phone numbers, with absolutely zero underlying text or audio content. Several of those target numbers were ultimately traced back directly to secure, off-grid encrypted server routing hubs. 1 year back, a completely separate federal inquiry was initiated into systemic record-keeping compliance. The Presidential Records Act strictly mandates the permanent preservation of all communications linked to executive operations. An official representative from the National Archives went completely on the record, stating, "We identified substantial systemic data gaps that are entirely inconsistent with verified historical timelines." What occurred next? Trump's defense infrastructure argued that communications handled on purely private, non-governmental hardware do not fall under the statutory definition of official executive records. But look closely at the macro pattern that emerged over the last 18 months. Every single time a new federal investigation was publicly announced, there was a corresponding drop in public channel communication volume and an immediate surge in encrypted application data transit. Legally, this pattern remained completely ambiguous until this week. Judge Morrison's unsealed order completely rewrites the operational framework. She has established a new legal precedent. The moment an individual is aware of an active federal investigation, migrating communications to self-deleting encrypted software can be classified as an overt act of obstruction of justice. That is entirely new legal ground. It is the first judicial ruling of its kind, applying historic document preservation acts directly to modern consumer encryption platforms. You can easily see where this trajectory is heading. This goes way beyond one political figure. It is about how modern technology challenges the very nature of legal accountability. Hit that like button right now if you think this deep dive legal perspective matters more than standard media talking points. Let's look at the exact breakdown of what happened at precisely 2:17 p.m. on Wednesday afternoon. Judge Morrison delivered her ruling directly from the bench. The courtroom went dead silent as she read the core finding. The court finds that the defendant's highly specific patterns of encryption adoption constitute a willful evasion of legitimate investigative processes. Instantly, Trump's lead defense counsel stood up to request an emergency judicial stay pending a formal circuit court appeal. Denied. The judge immediately locked in the strict 11-day compliance countdown clock. It took less than 47 minutes for the entire legal environment to change. Now, let's dissect the massive bombshell that every major network completely missed while they were focused on the broad encryption headlines. Deep within the unsealed transcript, prosecutors revealed a devastating operational secret. The Department of Justice has already secured the full cooperation of one of those 14 encrypted message recipients. Not only are they cooperating, but they have already handed over 23 specific encrypted messages that they manually screenshotted on their own device before the automated self-deletion timer could wipe them from the network. The judge reviewed those 23 messages privately in her chambers. Her immediate reaction to seeing that raw content was to completely expedite the prosecution's evidence production timeline. Her decision wasn't reactive, it was highly calculated. You can find the proof tucked directly inside footnote 7 of the unsealed ruling. Having directly reviewed specific data samples provided by a verified cooperating witness, the court finds overwhelming probable cause that additional encrypted communications on the target devices contain material evidence. She has already seen a piece of the puzzle. That is the real reason why she systematically rejected every single defense motion to block the disclosure. The The prosecution didn't just walk into court with theoretical arguments about metadata. They walked in with real, physical text logs, proving exactly why they required access to the remaining devices. We do not know what those 23 messages explicitly state. They remain heavily under seal. But whatever was written in those screenshots was powerful enough to convince a conservative federal judge to completely override every single privacy and executive privilege claim presented by the defense. A former assistant U.S. attorney, a veteran who spent 19 years prosecuting complex public corruption cases, remarked immediately following the adjournment, "Federal judges do not truncate compliance timelines or pierce privacy privileges unless the sealed evidence presented to them in chambers is absolutely undeniable." This gives you a clear window into the prosecution's real leverage. The public is watching a slow-motion battle over encryption principles. Prosecutors are already way past that hurdle. They have insider cooperation, physical screenshots, and now full judicial clearance to capture everything else. Don't go anywhere, because what we examine next completely changes how you calculate the risk of this entire case. Drop your prediction in the comments right now. What do you think was written in those 23 screenshotted messages? Write it down, then keep watching. What are the leading digital crime experts saying behind closed doors? A former chief of the Department of Justice's Computer Crime Section, who spent 14 years managing high-level digital evidence tracking, stated flatly, "This specific ruling completely strips away the absolute shield of commercial encryption during active federal litigation. It means courts can now legally dismantle encryption claims if a pattern of criminal intent can be established through chronological metadata." A prominent cybersecurity law professor at Stanford University added another layer. "We have officially entered unmapped legal territory, where the mere deployment of a privacy tool can be utilized by the government as circumstantial evidence of a consciousness of guilt." The key takeaway here? The software itself isn't against the law, but the chronological pattern of when you deploy it can become the primary evidence used against you. Even a prominent former White House counsel, who managed executive compliance operations during a previous administration, admitted during an industry panel that the best practice for any modern political figure is to always operate under the assumption that every single digital string will eventually face a public docket. When legal minds from both sides of the aisle start agreeing on that structural point, you need to pay very close attention. The consensus among elite legal analysts is clear. Encryption alone is perfectly benign, but the specific timing and behavioral patterns of its installation can be used to legally establish intent. Meanwhile, the technical community is expressing deep alarm over the broader societal implications of this ruling. The chief technology officer at the Electronic Frontier Foundation issued a stern warning. Any legal or technical backdoor mechanism designed to allow law enforcement to bypass consumer encryption inevitably creates an existential security vulnerability that can be exploited by hostile foreign adversaries. These privacy advocates aren't stepping up to defend a specific politician. They are looking at the macro architecture of digital freedom. If a federal judge can force platforms like Apple or Signal to assist in the recovery of deleted messages under the threat of massive daily contempt fines, that expansive investigative power will eventually be claimed by corporate civil litigants, international state actors, and domestic divorce attorneys. A former NSA technical director with 23 years of experience in signals intelligence summarized the crisis perfectly. "You cannot build a secure digital door that only opens for the good guys. Either encryption is mathematically absolute for every single user on the network, or it is functionally secure for no one." This leaves us with two entirely separate, massive debates running concurrently. The legal debate. Did the former president intentionally cross the line into obstruction? The technical debate. Should federal courts possess the systemic power to break consumer privacy tools? Both questions are deeply critical. Both are incredibly complicated. Let's look at exactly why this structural shift affects your everyday life. This is the real talk about how these elite legal battles alter reality for regular people. Digital privacy as we know it just took a massive hit. If you utilize platforms like Signal or WhatsApp under the assumption of absolute privacy, you need to realize that those protections stop at the courtroom door. If you are ever involved in a civil dispute, a corporate contract battle, or an intense employment lawsuit, this unsealed order establishes the clear legal precedent that your personal device transition history can be scrutinized to build a case against you based entirely on timing.